We can start.
Good evening, colleagues. I'm so glad to be here tonight, and so glad to have you all here with us. I'm Dr. Angelique Coetzee, the National Chairperson of the South African Medical Association. And on behalf of the association, I again want to welcome you all. I want to remind you that we have held a number of these webinars specifically aimed at the medical profession in the past few months, and the popularity is increasing of these webinars. The topics we address and the caliber of speakers we attract are among the main reasons these sessions are so well attended. Of course, the fact that these webinars are online and that you can interact with us from the comfort of your personal spaces is another reason. But rest assured, we are committed to keep these webinars a regular feature of our offering to all members and non-members, just to ensure that we are all adhering to the correct etiquette of these meetings. I would like to ask you all to mute your microphones if you aren't speaking, and also to switch off your cameras. You will see from the program that there is a specific time allocated for a question and answer session. So I'd like to request you all to observe these and keep your questions for this time slot. Tonight's webinar touches on another interesting topic affecting doctors. Doctors being able to earn during the COVID-19 while also being compliant with the National Credit Act, something we don't know a lot about. We are, however, all aware of the economic impact the country experienced during the COVID waves, as well as in the current pandemic that's still not over yet, and of the personal finance blow many doctors faced or are facing. I think, therefore, that the webinar on earning during the pandemic, especially in the context of the National Credit Act, is extremely timely and useful. Tonight, I am honored to welcome Mr. Howard Gabriels as our guest speaker. Mr. Gabriels was appointed as the Credit Ombud in February 2021. He previously worked as the interim Credit Ombud since November 2019. Mr. Gabriels has a long career in the public sector and has held various leadership positions. He was Deputy Director General in the Department of Communications in the late 1990s and served as the Chairperson of Stats Council from 2005 until 2013. He is currently the Chairperson of the Board of Directors at Proudly South African. And here's the important thing. All his degrees. He's a real mathematician. So Howard completed an MPhil in Urban and Regional Science at the Stellenbosch University in 2012. In addition, he holds a BSc in Mathematics and Mathematical Statistics and a B.Con Honors degree from the University of the Western Cape. Thank you so much, Howard, for joining us tonight. I am sure we are all eager to hear more from you and understand how we as doctors need to ensure we remain compliant in these difficult times. I'm now handing over to you, Howard. Please enlighten us and teach us something. Thank you so much.
Thank you very much, Dr. Coetzee. I'm just sharing my presentation on screen. Again, a appreciate the opportunity to share some thoughts with you from the Credit Ombud. I'm going to go through this presentation talking a little bit about what the Credit Ombud does, some of the regulatory changes in that space, and then get back to the challenge doctors face, especially in relation to the National Credit Act. Sadly, the person who introduced me to Dr. Coetzee is not with us today. She passed away just over a month ago, and she is one of our council members, Ms. Marie van der Merwe. So I want to keep in mind the fact that she has been the real person that was pushing for us to meet in this way. And unfortunately, she cannot join us. Okay, so let me start with the mission statement of the Credit Ombud. The Credit Ombud will effectively resolve disputes between members of the credit industry and credit receivers, that is the consumers and businesses that credit is granted to, with regards to credit matters and credit information matters. And I will talk a little bit about those two later on. We also act as an educator of the public in matters pertaining to the credit industry. A large part of our focus here is on consumer education, but we see this role that we're playing tonight in educating people who may be granting credit also as an equally important task. And then the foundation of our value system is that at all times we must act honestly, independently, and fairly, balancing the rights of all parties. When I started working a long time ago, I worked as a trade unionist. So you will understand when I say the Ombud is not a shock steward for the consumer. The consumer comes to the Ombud, and the Ombud tried to facilitate, to mediate whatever the appropriate mechanism is to find a resolution of the dispute between the credit provider on the one hand and the consumer on the other hand. Then as background, we're an Ombud with jurisdiction, and that jurisdiction was originally in terms of the Financial Sector Ombud Schemes Act, and was first granted in 2006. That has changed now, and the recognition is now sitting in terms of the new act that was promulgated in 2017, the Financial Sector Regulation Act. And I'll talk just for a brief moment about that when we get there. Then, which is important for you, if you become a member, the Credit Ombud is a registered benefit organization with SARS, which means that the membership fees that you may pay could be tax deductible. Now, what is our jurisdiction? We cover broadly two areas, as I indicated earlier. The first is mostly related to the credit bureau. So it's credit information matters, which is really about the information that are listed on the credit bureau and disputes consumers may have. So a consumer may say, I've got this adverse listing against my name on the credit bureau, and it should be removed because that matter has been settled long ago. So that's really an important area of our work. The second part of our work is what we call non-bank credit matters. And here, our membership covers what we call non-bank. In other words, anybody that grants credit that is not a bank. So it includes the furniture retailers, the clothing retailers, the micro lenders, non-bank vehicle finance. So for example, Toyota finance would be is a member of the Ombud. Non-bank property finance, such as SA Home Loans, is a member of the Ombud. Here again is we governed by a council, and we have the independent members of council. Mr. Raditipole is the chair of the council, and he's an attorney. Ms. Tandiwe Zulu is from the Black Sesh, and she's the deputy chair. I've just told you about Ms. Mari van der Merwe, who represented the South African National Consumer Union. And then Ms. Tuli Zungu is a journalist. So we have two organizations that broadly are representative of consumers, and two people that are completely independent. Then we have three members that represent the credit industry. Ms. Janine Nudeful-Yun from the Credit Bureau Association, Mr. Arthur Klubi from Large Non-Bank Lenders Association, and Mr. Michael Lawrence, who's from the National Clothing Retail Federation. Just to give you a sense of our statistics over the last 3 years, and in 2019, there was a major change that was introduced in the organization, in that we agreed with the banks that will no longer deal with credit information matters on behalf of the banks. And we've transferred those complaints to the Ombud for Banking Services. So you can see the complaints and inquiries dropped quite significantly last year to about 16,000 calls, which is in part a function of those months of April and May, where things went very quiet in our offices, has come down to 30,120. Disputes opened 3,143. And it's important to note that we've had 16,000 complaints and inquiries, but we only opened 3,143. And often it is that we would ask the consumer, did you contact the credit provider, and get a reference number from the credit provider before you come back? And it appears that a lot of consumers would then go back to the credit provider, and the matter is resolved and doesn't come back. Similarly with the credit bureaus are obliged to deal with a complaint of a consumer within 20 business working days. So a lot of those complaints don't come back as disputes. And then the disputes closed is very close to that number. It takes us on average 46 days to resolve a dispute. So some disputes really get dealt with quickly, but others could last quite a while, and we have a few that last much longer than what we would like. And then we spend a lot of time in advertising, and you can see how significantly it dropped in 2020 as we were reconfiguring ourselves in the COVID times. Despite that, the customer satisfaction survey has stayed at the level that is acceptable to us. We have some important relations with the regulatory environment. So on the 1st of March this year, we concluded the Memorandum of Understanding with the National Credit Regulator, which provides as an alternative to disputes being investigated by the NCR against subscribing members of the Ombud. The NCR shall refer non-bank credit agreement and credit information matters to the Credit Ombud. We've also agreed that we will provide the NCR with quarterly reports, and then there are a number of areas that we are cooperating in respect of capacity building and training, consumer awareness and education, and also in research and information. Now, the Financial Sector Regulation Act is the other important act for us. And, and while the Act was promulgated in 2017, Chapter 14 of the Act was not promulgated immediately and only came into effect on the 1st of November 2020. The Minister of Finance appointed the Ombud Council in January this year, and the chairperson of the Ombud Council is Jean Wood. She's somebody that is well known to us because previously she was the CEO of the Ombud for short-term insurance. And then the minister also appointed the chief ombud on an interim basis, Ms. Eileen Meyer. She was appointed on the basis that she's going to assist the organization to set up the administration and is there on a 12-month contract. You can see the other members of the Ombud Council. There are two reasons why the Ombud Council is important. The first is that our recognition as an ombud with jurisdiction is now in the hands of the Ombud Council. We obviously, our recognition have been extended and probably in the next 6 months or so, we would have to make the necessary applications for the recognition to be further extended. The other part of the Financial Sector Regulation Act is Section 211(3), which states if a financial institution provides financial products and financial services, there's a recognized industry ombud that provides for resolution of complaints about financial products or financial services of that kind. The financial institution must be a member of that industry ombud scheme. So we really want to encourage you as doctors to become members of the Credit Ombud. Just to talk very quickly about the value proposition, and really it's about building confidence in financial markets. One of the key factors in increasing confidence is to provide an accessible and user-friendly arrangements to resolve disputes. For consumers, obviously they know that if anything goes wrong, there's somebody that is an independent body that will assist them to resolve the dispute quickly and informally without them really needing a lawyer. And then our services are free to consumers. We've also made it easily accessible for consumers to contact us. You can see that in the slides. But then the proposition to business is that businesses will obviously benefit when consumers enter into financial agreements, and the cost of resolving disputes with consumers are kept to a minimum. Also, that unscrupulous competitors who act unlawfully are held accountable. And then the cost per dispute is relatively low. Finally, to the credit industry, we alleviate the workload on the courts and assist business to resolve customer complaints effectively, cost effectively, and in a manner that satisfies both parties' expectations. We also address issues in the interest of a better industry and to resolve problems even before they become systemic risk. Often when we notice a trend in complaints that are coming to us, especially when they come from one credit provider, we would call up the CEO, the head of their legal department or compliance department, sit down with them, try to speak with them about what the problem is, and then try to see if we can assist them to streamline their processes so that we can avoid these problems from occurring. Now I want to begin to talk briefly about a handful of issues as it relates to the medical profession. And the first part is to understand what credit is in the context of the National Credit Act. It is defined as a deferral of payment of money owed to a person or promise to defer such payment, or B, a promise to advance or pay money to or at the direction of another person. Now, a credit provider, when you look at the Act, there's a long definition. And what I've done here is really just to highlight the point that a party who supplies goods or services under discount transaction, incidental credit agreement, or installment agreement is also defined as a credit provider. So what is an incidental credit agreement? It means an agreement in terms of which an account was rendered for goods and services that have been provided to the customer, or goods and services that are to be provided to a customer over a period of time, and either or both of the following conditions apply. A fee or charge or interest become payable when the payment of an amount is charged in terms of that account was not made on or before the determined period or date. Or two, prices were quoted for settlement of an account, the lower price being applicable if the account is paid on or before a determined date, and a higher price being applicable due to the account not having been paid on that date. So the incidental credit agreement is a bit of a misnomer because it is deemed to be an agreement. So if your patient has agreed to pay you at the end of the month, and then at the end of the month there is no payment, and you notify that patient that you're going to charge interest on the outstanding amount, then it is deemed that you have entered into an incidental credit agreement. It's important to understand that is how the Act is saying this part. Just before I talk about interest, in section 14, the question is who must register to be a credit provider. So the good part here is that doctors who are running their surgeries or whatever way they run their practices are not required to register as a credit provider. And in fact, I only realized later that I was working from an earlier version of the Act, and saw that because this provision of a person that is less than 100 credit agreements has changed to recently to a position where you must register even if you have one agreement. But the incidental credit agreements does not require you to register, which I am sure some of you will have a sigh of relief so that you don't have to go through the bureaucracy of registering with the NCR. Then there's a long discussion about what interest you can charge. And there's quite and you'll see in the next slide, I'll try to show you how some of the interest are calculated. But the easiest way to explain it is that a doctor can charge incidental interest on an incidental credit agreement up to a maximum of 2% per month, or the equivalent of 24% per year. Just to give you a sense, there are different interest rates for different things. So mortgages it is the repo rate plus 12% maximum. Credit facilities, it's the repo rate plus 14%. Unsecured credit transactions is the repo rate plus 21%. And developmental credit agreements is the repo rate plus 27%. But the incidental credit agreements, it's 2% per month. Now, what happens if a consumer is in default and you want to take action against that consumer as the credit provider now? Then the key here is that you must observe Section 129, and you also must observe Section 130, brackets 2. And I'll just quickly go through an explanation of Section 129. What Section 129 provide for is that first you must send a notice, and we generally in the trade refer to the Section 129 notice to the consumer in writing, and to say to the consumer, you are in default. There are remedies available to you, such as debt counseling, alternative dispute resolution, or you could go to the consumer court, or you could go to an ombud with jurisdiction, like the Credit Ombud, with the intent that if there's any dispute, the parties can reach agreement and develop a plan to bring the payments up to date. Then it says, subject to 132, and I will get to that in a moment, you may not commence any legal proceedings to enforce the agreement before first providing notice to the consumer as contemplated above, or in terms of Section 8610, as the case may be. 8610 is to do with debt counseling and so on, which in this case may not apply. And then Section 132 then says that you may approach a court for an order to enforce a credit agreement only if at the time the consumer is in default and has been in default under the credit agreement for at least 20 business days. But it's important to understand that when you get to court, the first thing they're going to ask you is, what is your section, where is your Section 129 notice? And then you've got to have proof that you have sent that Section 129 notice. So mostly people use a registered mail, and where the consumer has agreed, they use an email or whatever is the appropriate. Now, then it says that so you can now go to court to enforce that default under the credit agreement after 20 days, and at least 10 days have elapsed since the credit provider delivered a notice to the consumer in Section 129, as the case may be. So it's really important to understand this in terms of, if you decide to enforce an agreement, that you need to deliver the Section 120 or the Section 129 notice, and only after 10 days can you then take the case forward to deal with this. I'm sure most of you have heard about prescription, but just a legal definition. Prescription is a legal principle in terms of which a debtor liability to pay an outstanding debt is extinguished after the passing of prescribed time periods. Now, it's important that the prescription period can be interrupted by the consumer acknowledgement of debt. For example, if the consumer pays part of the debt to the creditor before the prescription period ends, or if summons is served on the consumer by the credit provider in order to claim payment. So those are the mechanisms. The another way in which acknowledgement of debt is also taken is where a consumer in writing or verbally acknowledge that they owe you money. So for example, when a call center calls the consumer and say, you remember the debt you had to Dr. Kutsia, and I say to the call center agent, yes, I remember that debt, but I'm not going to pay it. Now that call is recorded, and that could serve as evidence in a court case if that prescription has been breached as well. And then in the case of incidental credit agreements, the time period is 3 years. In other words, if there's no acknowledgement of debt, and if there's no summons issued from the date when the period starts to when it expires, is a period of 3 years. I'm going to stop there. I have two of my colleagues on the line. The one person is Avina. She's the head of our call center at the Credit Ombud. And then the second one is Lee Subrati. Lee heads up our case management team. And what I will do is all the difficult questions you ask me, I will pass to them, and I'll take the easy ones. Dr. Kutsia, thank you very much for this opportunity to share with you.
Thank you, Mr. Gabriel. That was certainly enlightening. And I think, as Dr. Kutsia indicated, probably an area where most of us in the medical profession would not be aware of some of those details relating to that. I'd like to open up the lines for any questions that colleagues may have for Mr. Gabriel, please. All right. So while colleagues may be thinking about the potential questions that they would like to ask, Mr. Howard, I was just wondering if you could highlight for us some of the frequently asked questions that you receive, and maybe if you could go through those for the benefit of our audience.
I think in part I've tried to answer some of the frequently asked questions in my presentation. And maybe the big question we often get, so a patient hasn't paid as agreed, what do I do? And maybe what I can do is ask Avita, so you hear one of my other colleagues, just to come in and add a voice to that particular question. Avita, are you there? Okay, it doesn't seem that Avita is responding.
Sorry, Mr. Gabriel, is that Avita Noble?
No foul, yeah.
I will make her a panelist and then she can answer the questions.
Okay.
So while we're trying to get Evita to answer that question there, Mr. Gabriel, I see I've got a question on the line. One of our colleagues asked if you could please advise as to what we can do when the claim has been paid directly to a patient and the patient refuses to hand over the funds to the doctor. Medical aids do this from time to time and would appreciate your advice on this matter.
Obviously, the consumer is indebted to the medical practice, and you know exactly what the cost is. There's an invoice. What you need to do is to obviously start off with a friendly reminder that the patient owes that money to the practice. And then if she doesn't respond to that question or refuses to pay, then you need to take the steps to recover. So the first step would be to go to Section 129, as I explained, and send a notice to the consumer. Then the next step is to wait for the response to the Section 29 notice, and to see if there is a negotiation that can take place to resolve the dispute. Then the third step would be to now take the matter forward to the institute legal action against the consumer. And then if you take legal action against the consumer, you are confident that you followed the prescripts of the Act, and which is the Section 129 and also the Section 132, 30(2), that you must comply with. And then you're going to have to get an order against the consumer. When you get an order from court against the consumer, then you can execute against the consumer, which basically means then that the sheriff of the court will go to the address of the patient and will attach whatever appropriate properties that could be sold to recover the money outstanding. So that's the normal legal procedure.
Okay. Thank you, Mr. Gabriel. I've got another question that I'll read through and ask you to think about it while we go to Avita to assist us with the first question. A colleague wants to find out if the interest rate of 24%, does that change when the repo rate changes? And can it be increased by other incident, be it an act or otherwise? Maybe we'll come back for an answer to that question. If I could ask Avita to come through with an assistance for the first question.
Good evening, everyone, and thank you for allowing me the opportunity to respond. So with the initial question being that if a patient fails to make payment on an outstanding amount that may be due to a healthcare professional, then what is the right course of action for that healthcare professional? Now, we understand, and there's no way that any one person can fathom the challenges that has come with COVID and the consequences therefrom. However, it's time immemorial that there will always be an issue with outstanding payments from patients to these healthcare professionals that we are addressing now. And I think, initially, presumably the healthcare professional will attempt via soft collection processes to try and obtain payment on the outstanding amount from the patient, or at least enter into a payment arrangement over a period of time. However, and your audience would probably be able to vouch for this, it's not always easy to obtain the outstanding amounts from patients for whatever reason. They could argue that they have lost their jobs, they just do not have the money, they avoid altogether any sort of communication with the doctor's rooms or the healthcare professionals' rooms, or they would highlight that the medical aid had failed to make payment, or as far as they understood, payment had been made by the medical aid. So a number of different scenarios in that instant. Now, with the patient blaming, for example, the medical aid for the non-payment, ultimately the buck stops with the patient. When contracting with the healthcare professional, understandably, the patient holds him or herself wholly responsible in the event that the medical aid has not made payment or made a part payment. Now, again, we also understand that in as much as the healthcare professional may have submitted the claim on behalf of the patient to the medical aid may or may not have paid the full amount. The responsibility would lie on the patient, being the consumer in this instant, to do a follow-up with their medical aid and ensure that payment has been fully covered to the healthcare professional. And in the event that has not taken place, of course, have a fight or an argument with the medical aid, and then cover your outstanding amount to the healthcare professional. Now, we also understand that between the medical aid and the healthcare professional, there would be a specific time frame from when the claim was submitted to when payment was finally made. But that again, responsibility lies with the patient to ensure that that follow-up is done to make certain that all outstanding monies are actually received by the healthcare professional. In an instant, however, that either the full amount has not been paid by the medical aid or the patient just simply refuses or neglects to make payment, after the healthcare professional has attempted from a soft collection perspective in-house to try and recover the monies, the chances are you would either write off that amount and no longer collect on it, and use the argument that should that same patient approach you in the future, you will not provide the services that they require unless the outstanding amount has been settled. But there is also an additional process for healthcare professionals to proceed with to ensure that they are making or earning an income during COVID and beyond COVID and before COVID as well. And that is debt collection. So ultimately, with all your attempts to collect via soft collection methods having failed, you could then hand over the account to a debt collector for collection when that consumer has failed to make payment, or that patient. So those are the scenarios available. And in proceeding to do such, the doctor, any other healthcare professional could liaise with the debt collectors to determine whether or not the debt collector could list the patient at the credit bureau, alerting any future credit providers, for that matter, that this individual is not good for his money. So, there are certain scenarios that can take place. I hope that's answered the question.
Thank you very much, Avita. Yeah, colleagues, if I can just go to the next question, the one on incidental credit. It is not linked to the repo rate. It's 24% at the moment, and obviously it can change only if the regulator changes it and the minister promulgates those changes. But that is the amount in the Act. Unlike the other areas, it is a flat amount that the credit that is provided for and it's in a regulation of the National Credit Act called Regulation 40. I think Avita started to answer the next question, which are we legally allowed to hand over a patient to a collection agency if they refuse to make payment within a reasonable time? Yes, you are allowed to ask somebody to collect on your behalf. And what often happens is that doctors would cede a book to a collection agency, and the collection agency would charge you a fee, which normally will be a percentage of what they collect. So that may well be a way to go ahead in doing that.
I think you've covered all the questions there,
Yeah.
Mr. Gabriel.
Yes, I think I've covered
Yep.
both questions there.
Okay, and I think the others, our colleagues are saying thank you for their assistance.
Maybe if I can just say,
Sure.
we obviously see a number of people coming through in this time. These are now consumers coming through in this time. Maybe just one or two comments about that. The one thing we notice is that a lot of consumers are trying to pay up their accounts, and I guess it's their way of trying to get out of debt as the pressure of reduced income or sometimes gaps in income is pressurizing. So we see a lot of consumers coming to our office saying, I want to close my account, and the credit provider don't want me to close the account. This specifically relates to retail accounts, which I think is an interesting trend that we've seen large numbers of consumers. And basically the issue there is sometimes the consumer would go and ask, what's my outstanding amount? And then they pay the outstanding amount, and they think the account is now closed because it's paid up. But then the next month, they see there's now new charges for admin fees, for the club membership, and so on. So it's important to understand that in this space, a lot of consumers are now educated and beginning to ask for the account to be paid up and to be closed, which is an interesting trend that we see in there. The second interesting trend, which is in a way surprising, is we've had more matters than usual about credit insurance, where consumers paid insurance and the insurance hasn't paid out. And it's interesting that that is more prominent in the period post-COVID, especially as many people have been retrenched. So you can see how the industry has been impacted. According to the information that the National Credit Regulator holds, is a large number of consumers are struggling to meet all of their obligations during this time, despite the interventions of payment holidays and so on.
Okay.
I see there's a question.
Yes,
Yes.
I was wondering if you could assist us with that one. A colleague says that I've asked to hand over a patient, and then the patient died due to liver failure, got no payment, and then got a legal letter from the attorney stating that the client, which is the wife of the patient that died, was divorcing the patient at the time, and therefore they're not owing anything. And maybe you can combine that one with the last one, which says, can I add 2% per month, even after 12 months? If you could assist us with those two.
Okay, so the first one, and I'm going to ask Avita to come in here as well. Just my understanding is that the outstanding amount that is due to you as the medical professional is still due, because that outstanding amount must be claimed against the estate of the patient that passed away. I know, Avita, maybe you want to add to that.
Thank you, Howard. Yes, you're quite right to answer the question posed by the person raising it. So in the event that there's an amount due and the patient had passed on, there would be a claim that could be submitted to the estate of the deceased. Also very important to understand that the terms and conditions of life policy may come into play, but that is something that would need to be determined on a case-by-case basis. Thank you.
Okay. I hope
perhaps
we have...
what I could also suggest is if the individual would like to contact us to just traverse that specific question further, we would be most happy to engage and discuss and provide direction.
Thank you so much, Avita. We'll put the contact details on the screen as we finish the webinar. The last one then, please, Howard. The colleague wanted to know if they can add 2% per month, even after 12 months.
Okay, so after 12 months, the account is not paid, but the account is in existence. It hasn't prescribed. I would say yes, you can go to that consumer and say, I am now charging you interest on this amount. If you don't pay, then you can. And if you don't pay, then I'm going to take further legal steps. So that you would be perfectly entitled to add the 2% interest per month on that account. If it is after 36 months and the patient did not acknowledge in that 36-month period that she owes you any money, and that you have not initiated any legal action, then that account would be prescribed, and then you have forfeited the outstanding amount. So in the 12-month period, you can still take steps to recover that money.
Okay. Thanks, Mr. Gabriel. Colleagues, I think we have come to the end of our session. There was one question that I think probably just highlights some of the frustrations that colleagues face in collecting funds from the patients, and I think probably just would be worth reading through it. Probably not really much need for responses, but the colleague says that the patient was promised that they would be covered by the medical aid, and he promised that he would make the payment. Subsequent to that, they blocked all forms of communication since that time. It has been over 6 months, has been handed over already, but as we speak at the moment, they haven't been able to receive anything and have gotten nowhere. I don't know if you have just maybe some closing comment on that question, Howard?
Yes. A lot of credit providers, especially the smaller credit providers, are using collection agencies to help them collect on an outstanding debt, precisely because the amount of time that a medical professional must spend on chasing the money that's outstanding to them may be very, very onerous. But in that case, it's clear a service was delivered. It is clear that money is due. There is evidence that submissions were made to the medical aid and the medical aid paid the patient. you have to follow your rights and follow the legal procedure to recover the outstanding amount from the consumer.
Yeah. Thank you so much, Howard and Avita. Colleagues, I'd like to apologize for not showing my face. We had some technical glitches, but as you would notice on the screen, it's Dr. Nhlapo who has been coordinating this question and answer session. We'd like to thank the presenters for tonight, but I'd like to call upon Dr. Mzugwa, who is the Vice Chairperson of the SA Medical Association, to give us some closing remarks and thank the colleagues for us.
Thank you very much, Dr. Nhlapo, and good evening to colleagues. Once again, we have touched, on an important topic relevant to our profession. It is because of the insights we gain from the experts, speakers we attract, that we are able to produce these important sessions. These virtual events cannot be held without the tremendous input from obviously those behind the scenes, and I'd like to thank all the SAMA personnel who made this event possible, especially the CEO of SAMA under his leadership, Dr. Nhlapo. I would also like to thank the chair of the South African Medical Association and my colleague, Dr. Angelique Coetzee, for her introductory remarks. A special word of thanks to you, Mr. Gabriels, for who made obviously himself available tonight for his input on this important matter. Thank you to everyone who joined. Thank you to everyone who joined tonight. We continue with these webinars because of your involvement, and the feedback you give each session is critical to help us provide you with the most relevant speakers at any given time. With these short remarks, I would formally close the proceedings. Thank you all again for attending.
On the screen.
Until next time, goodbye.
Ask him to put. Thank you.
Thank you for having us.
Thank you very much, colleagues.
Thank you, colleagues. Good night.
Good night. Thank you.
Good night.
Bye.
Thank you. Good evening.